Good morning, sir. Good morning, classmates. I am Jimar Gibukog from BS Criminology 3 Delta. Today, I am going to discuss about our activities. Number one topic is the classifications of felonies according to their means by which they are committed. According to Revised Penal Code, Article 3, the felonies are classified into two by which they are committed by means of dulo or deceit or the intentional felonies. And number two, the culpable felonies or the culpa or fault. These two types of felonies are distinguished from each other by the presence and the absence of malicious intent or intention. And the intentional felonies, the act is committed with malicious intent, or the injury has intention because of the intention of the offender. Number two, the culpable felonies, or it is the incidents cause of negligence, imprudence, lack of foresight, and lack of skills, or this incident is not intentionally done. It don't have intention or without malice. Okay, let's go to the second topic. The felony is not the proximate cause of the resulting injury. Yes, it will. First, when there is an active force or act between the felony committed and the second, the resulting injury. And the felony committed is distinct, or it's not the reason why the injury is naging malala. For example, when you are driving a car, then you hit someone, then you bring it to the hospital. By the way, you hit someone because of lack of foresight, but yeah, lack of foresight, lack of skills, then you hit someone. You bring it to the hospital, then in a continuous sequence, your act is not the reason of the past event or the future event, or the result is your act is distinct. Then when you bring the victim to the hospital, you done your duties. You help the person you hit. You don't run. Yeah, you don't hit and run, but you help and bring it to the hospital because your act is not intentional. You help him. Then the second action is the duties of the doctors and the nurses inside the hospital. This is the resulting injury cause, or has the effect, or the cause, the second cause. You bring it to the hospital. The doctor and the nurse, they don't fulfill their duties. So it is the reason why the cause or the death, or is the cause of the incident, because of the duties of the nurse and the doctors. They aggravated the victim or the patient, so it is dead, or the injury has been caused bigger. So the committed felony is not the proximate cause, because of the sequence, then it is distinct. it is not proximate cause of the injury, but the aggravated of the nurses and the doctors in fulfilling their duties. Okay, let's move on to activity 2. Number 1, distinguish intent from motive and criminal law. Okay. Intent, it is usually the mental aspect, or it is the intention of the criminal to be the result of his act. The intention, it is the purpose of his act. For example, the criminal is planning to kill, then his purpose or his intention is to do revenge to someone who he hate. He has the intention to do a revenge, then he's going to kill it or result some damage to that person. Okay, let's go to motive. When we say motive, it is the cause. It is the cause that moves. It is the cause that moves person to induce a certain action, or it means it is the reason or motivo. The motive, for example, what is the reason or his motivo to perform crime? That's the motive. Okay, let's move to another topic and activity 2. Question, make crime committed without criminal intent? The answer is yes. This will fall under the Article 3, the classification of felonies. Then it will be the culpable felonies, or without the intention. It is unintentional felonies. The intention or malicious intent is substituted with negligence, imprudence, lack of foresight, and lack of skill. Then the crime can be committed with a criminal intent. Okay, let's move to another topic and activity 2. What is equipoise rule? Equipoise rule, where the evidence in the criminal case is evenly balanced, or on the other side is balanced. The guilty and the innocence of the accused is balanced. There is no enough evidence or sufficient evidence to prove the guilty of the accused. Then it is in favor to the accused. The court or the constitution will be in favor to the accused, because the other side don't have the sufficient evidence to prove the guilty of that party. Then the result of the court or the declaration of the court, it will be the acquittal, because there is no evidence or enough evidence to prove the guilty of the party. Okay, let's move to activity 3 with a question of what is the role of lenity. The role of lenity is closely related to the dubio pro reo, which means is when in doubt, then it is the rule for the accused. The rule of lenity is when the court is facing two possible interpretation of the penal statute. Then the two interpretation of penal statute, the one is prejudicial to the accused, and the second is in favor to the accused. Then the court will interpret that too or decide. So this goes to it, the rule of lenity. The rule of lenity adopts the interpretation is more lenient to the accused or in favor to the accused when in facing with two doubtful result or two doubts of the party. Then the rule of lenity goes into it in favor to the accused. That's the court will respond to the rule of lenity. Okay, let's go to another topic, the ex post facto law. It's ex post facto law. It is retroactive. Retroactive, it means yung pabalik, retroactive, or looking back at the past, that happened at the past. Retroactive. This law is the exemption, or the Congress cannot pass this kind of law. It is the ex post facto law. For example, it is criminalized the action. It criminalized the action when it was committed is legal. It criminalized it. Ex post facto criminalize it. Or you are innocent when you do that action, then you will be liable you will be liable later on when the Congress passed that law. So that's not applicable. For example, from the Latin word nolum crimen nolla pena sine lege, it means there's no crime when there's no penal statute punishing it. So we will base on that. There is no crime when there is no law punishing it. So that's why ex post facto law are not applicable for the Congress to pass that law. That's his exception, but he has the power to make law. Okay, let's go to the last part, or the last but not the least, activity number 4. Activity number 4. The case of Bitoy and Tutoy. Okay, question number 1 in activity 4. Is Bitoy criminally liable of his act against Tutoy? The answer is yes. He is criminally liable even if he is minor, 17 years old, because he acted with discernment. Striking or striking to the head using 2x2 hardwood to the head of Tutoy is criminally liable, or it is punishable by law, or it is a crimes against person. So that's why Bitoy is criminally liable for his act. Okay, let's proceed to another question. Assuming if I was the investigator of the case, if Bitoy if Tutoy is dead, what will be the crime committed by Bitoy? For me, the crime committed by Bitoy is murder, not homicide. Murder because he struck the 2x2 hardwood to the head of Tutoy with deliberate intent. Or the murder is homicide with intent. It's not homicide, so it's murder case. Let's move to another question. If you are the lawyer of Bitoy, the accused, how do you defend him? If I were the lawyer of Bitoy, the minor, 17 years old Bitoy, I will defend him using minority, passion, and obfuscation, because he is just minor, and that bully guy, Tutoy, he is a bully, so he can I can defend Tutoy without using that, or against him, the minority, obfuscation, or passion. Okay, let's tackle another question. If you are the lawyer of Tutoy, how do you attack the defense of Bitoy? Okay, if I am the lawyer of Tutoy, the victim, the defense of Bitoy is minority, passion, and obfuscation. Then I will attack it with discernment, because the act of Bitoy striking 2x2 hardwood to the head of Tutoy is the act of discernment, or with intent. So I can defend and attack their defense with discernment, or the act of Bitoy is deliberate intent. Okay, let's move to number 5 question. If you are the judge, how do you decide the case? If I am the judge, first, I will take a look to the suspect, or the accused, the child in conflict with the law. He is just 17 years old. I will be in favor to Bitoy. He is just a minor. And based on Article 12 on Revised Penal Code of the Philippines, he is exempted for criminal liability, because he is just a 17 years old child in conflict with the law. And even if he is determined that he is guilty for the offense, he will be under the article number 80 in the RPC. The article number 80 is the suspension of the punishment to the minor delinquents. So the DSWD will handle that. Okay, let's finish this. Let's go to the very last part of our discussion. Number 6 question and activity 4. If Bitoy is criminally liable, and what doctrine he may be liable? For me, he will be liable in the doctrine of battery, because the victim is not dead. It's just damage or injury to the person. So the act of Bitoy is battery against Tutoy, because he intentionally violent or damage that person. by striking at the head by 2x2 hardwood. So he will be pulled under the battery. It's not also assault. It's not assault. It's not homicide or murder, but it is battery because uh, he do that by or that violence intentionally. And Tutoy is still alive. So that's it. Battery. Thank you so much. That's only a few of my explanations and discussion because I don't have ideas to the other topics. So I'm sorry. Thank you, sir. Hope you consider this video. Thank you so much.